atibatike zvechopu.
Right, ndadzoka neupdate ya Prophet Walter Magaya. Aya vanhu vakuru ava kwavana ndodira chinowanika prophet mane vekuprophetic healing and deliverance ministries ndofounda ka vaMagaya. So nyaya yamagaya ine yava iko zvinezvi. I know a lot of people manga kubva pakatanga nyaya yacho since day one pachinzi Magaya asungwa, nyika yese yakashamisika kuti Magaya asungwa aita sei. It's just that these days tete dzimwe nyaya dzatechimhanya nadzo, but ndangona kuti iya lusiwe ida kuti tinyatsokuirowa kusvika zvanaka kusvika tazoona kwainoperera kunoperera muto wenyaya yacho. But now word in the street iri kutenderera, iri kubuda, word iri kubuda nekumatare ikoko handiti muona nyaya yacho pari kunzoni Magaya asks his magistrate to refer rape charges to constitutional court. Baba Yada vari kutombovhura Hombe, Baba Junior, Baba Yada. Right. Magaya has applied for rape allegations by 3 women to be referred to the Constitutional Court, alleging prosecutorial misconduct, irregular DNA procedures, and violations of his right to a fair trial. Magaya told the Avhura Regional Magistrate Court on Tuesday that the prosecution has acted improperly and that the criminal process against him has become unconstitutional. In an affidavit tendered by his lawyers, Magaya said this is an application for referral to the Constitutional Court of certain questions touching on the validity of certain processes which affect my fundamental right. Magaya is facing rape allegations by 6 accusers, but his application for referral to the Constitutional Court only mentions 3 women. He maintains the allegations are false. I stand charged with 6 counts of rape relating to 3 complainants. He says, I have constantly and vehemently denied all these allegations. Magaya's application places significant weight on an affidavit filed by one of the complainants who stated that she no longer wishes to testify. Magaya says the affidavit was served on the National Prosecuting Authority, but a senior prosecutor initially denied its existence. I fortunately managed to lay my hands on the withdrawal affidavit relating to name of women withheld, which had been served on the NPA but had been alleged to non-existent. He says the affidavit confirms that the complainant no longer wishes to testify and she has communicated his position to the prosecutor general. Magaya argues that continuing the prosecution in such circumstances is illegally untenable. A complaint originates from a complaint while a charge originates from the state, yet a charge cannot exist in a vacuum. It is founded upon the complaint, he says. Without the complaint, the charge collapses. Magaya also accuses prosecutors of improperly interfering with evidence relating to another complainant who lives in the Republic of Ireland. According to the affidavit, a senior prosecutor told the court that the state was amending a witness statement, something Magaya says exceeds the role of prosecutors. The recording and amendment of witness statements is part of investigations, which is the exclusive role of the Zimbabwe Republic Police, he says. In his case, the public prosecutors admitted to amending a witness statement, clearly dissatisfied with the original version because it did not advance the narrative they intended to choreograph against me. Magaya says he never served with the original statement that led to his arrest and was instead given a later statement dated February 27, 2026. The net effect is that I stand accused on the basis of manipulated and unlawful process where the prosecution has abandoned its constitutional role of impartiality and has instead descended into the arena manufacturing evidence to sustain charges, he argues. Magaya also disputes how police obtained his DNA. He says investigators secured a search and search warrant without allowing him or his lawyer to make representation before taking him from the Harare remand prison to Parenyatwa hospital where samples were extracted. I was then taken from Harare remand prison to Parenyatwa hospital against my will and in the absence of my legal practitioners where my DNA was extracted, he says. Magaya further claimed that the result of the DNA test have not been disclosed to him. I have not been served with the result of that DNA test, nor I have been informed of what has happened to the samples, he says. I cannot prepare a proper defense when the state conceals evidence that is itself deemed important enough to obtain through a court order. Magaya wants the magistrate to refer several constitutional questions to the Constitutional Court, including whether the National Prosecuting Authority's decision to proceed with the trial violations his rights to equally before the law, liberty, and fair trial. I submit that the issues that I raised are serious and warrant the grant of relief upon their consideration, he says. The relief they entitled to me is an immediate cessation of this unconstitutional process. If the application is granted, the criminal proceedings in Magistrate Court would be stayed pending the Constitutional Court's determination of the issues. Vamagaya vatotaura vapedza. Totangira papi. Kune dzimwe nyaya dzekuti uri kuzwa kuti pamunondo pamusasa ngatiperere pana baba ikaisa. Andana icho chekuedha right mazvinzwa.